All right. Hello, everyone. Hope you can all hear me well. Sounds like it. I wanted to welcome you all to this UNAAQ public forum. Before we get started, I would like to acknowledge the traditional custodians of the land on which we meet, the Turrbal and Yuggera people. I pay my respect to their elders, past and present, and also extend that respect to all Aboriginal and Torres Strait Islanders peoples here today. I'm Liz, for those of you I haven't met before, and I'm a PhD student at the University of Queensland. A little over 1 year ago today, I started a 3-month-long internship with the UNAAQ through my degree. Since then, I've continued volunteering for the Peace and Security Group, and I would just like to recommend anyone who hasn't done so yet to please consider signing up and volunteering with us. We have an amazing cohort already, but we would, of course, very much love to grow. Today, we are, of course, going to hear about the roles of the ICC and the ICJ with a focus on Palestine and Israel. This relates to war crimes, human rights, and genocide, as well as the responsibilities of states like Australia that have accepted the ICJ's jurisdiction and also signed the Rome Statute. I want to soon hand over the mic to Professor Susan Harris-Rimmer, who will be leading the talk today. Susan is a professor at Griffith and focuses on international human rights law, climate justice, and gender equality. She often acts as policy advisor to the government and has provided policy advice on the United Nations Security Council and the G20. Perhaps most importantly, though, she is our president here at the United Nations Association Australia Queensland Division, so please join me in welcoming Susan.
Well, so what's lost? Yeah, a bit tricky. Trying to get on camera, but also be seen. Yeah, there we go. We'll try that. This is for posterity here. So my role today is first to offer an acknowledgement of country. I'd like us all to really think harder in this context of peace and security, of invasion and armed conflict and of violence, that we are standing on Indigenous land that was never ceded. I'd like to pay my deepest respects to the Jagera Turrbal elders and welcome very deeply any Indigenous person who's here today. And to remember this site, this exact site on the banks of the Maiwar in Meanjin is the site of conflict and occupation. So I think it's really important when we talk about peace and security issues that happen in other countries that we always reflect on our own country, and that we think about the very important truth-telling process that is happening in Queensland at the moment, led by our dear friend Josh Creamer, which is a really important process for Queensland. We have a lot of truth-telling to do of our own. So I also, before we start, I'd like to acknowledge many wonderful people in the audience. I'd like to acknowledge our National President, Danelle Davis, for United Nations Association Australia National President, our former President, Claire Moore, who's also a former federal senator. Welcome. Thank you very much for coming, Claire. We have lots of wonderful people in the audience, and including members of the Executive Committee. So thank you for coming. And I'd also like to just say hey to my fellow Griffith University Law School colleagues who are here to support our wonderful colleague, Simon McKenzie. I am absolutely blessed to work with this very clever man. But even so, I feel really terrible to know I didn't realise his PhD was on this exact topic. So we are incredibly lucky to have Simon. I remember when I suggested, I was like, Simon's really good at this stuff, but I didn't realise it was this stuff, exactly this stuff. So Simon's research focuses on international criminal law and international humanitarian law, the idea that even wars have limits. He is a wonderful theorist, but also very, very good at doctrinal and practical dilemmas that face those who are working in the area of international criminal law and international humanitarian law, of which there are many. And he's currently looking at defence and security applications of science and technology, which are, as we know, incredibly difficult, and which were raised at our Summit of the Future National Forum recently in Canberra, in terms of we had the Killer Robots campaign, thinking about AI and future weapons. Prior to joining Griffith, He was a research fellow in the Law and the Future of War research group at the University of Queensland, and we have some UQ colleagues as well here today. That group investigates the diverse ways in which law constrains, enables or ignores technological change in the context of national and global security. And they particularly focused on autonomous functions of military platform systems and weapons. And he's still an honorary fellow with this group. He's also worked for the Victorian Department of Justice and Community Safety, working on family violence reform, and he's held roles at the Melbourne Law School, the Supreme Court of Victoria, and the International Criminal Court. Simon graduated in 2011 from University of Tasmania with an arts law degree with first-class honours in law, and was admitted to practice in Victoria later this year. And he received his PhD from the University of Melbourne in 2018. And his thesis has been published as a book, which would make, I might say, a wonderful Christmas present. Just saying. In someone's stocking that you love, you could pop Disputed Territories and International Criminal Law, Israeli Settlements and the International Criminal Court, published with Routledge in 2019. So please, really, really delighted to have you. Please welcome Simon.
Thank you, Sue, for that very kind introduction, and for helping to get my royalties up for the... Great. So I also acknowledge that we meet on the lands of the Yagara and Turrbal people, and I think when we think about Israel and Palestine, clearly it's an issue about land and who controls it, who gets to use it. So it is always appropriate for us to remember when we're on land the history of this place and the conflict. So I pay my respects to their elders, past and present. All right, so thank you all for coming today on this hot Saturday, frighteningly hot Saturday, and to the organisers for the opportunity to speak about how two leading international judicial institutions, the International Criminal Court and the International Court of Justice, have been grappling with the crisis in Israel and Palestine. So this is important for its own sake, but it also reveals something of the possibilities and limits of international law and its institutions. It can also help us assess the legal responsibility of other states, such as Australia, in the face of recent events in Gaza. Before we start delving into the details, I want to give two caveats. First, I want to acknowledge that discussing Palestine and Israel is fraught. Much depends on how a shared history is interpreted and where in time we decide to start the telling from. You have no doubt witnessed examples of this in conversations you've had in the news articles that you've read. It's a major feature of the political debate about war in Gaza in Australia and around the world. So it's evident that the chain of events that began on October 7th with Hamas's attacks has led to an inconceivable amount of suffering, starting with the civilians killed or kidnapped in southern Israel, and followed by the Israeli assault on Gaza that has included the killing of tens of thousands of Palestinian people, including many children, and the displacement of almost the entire Gazan population. However, starting with the attacks by Hamas on October 7th does not recognise that this new Gaza war is the latest iteration of a much longer conflict over land, resources, and the movement of people in a place that's smaller than southeast Queensland. So there are many places that we could start telling this history. We could start the story with with Israel's unilateral withdrawal from Gaza in 2005, or with the breakdown of the Oslo Accords in the Second Intifada in the early 2000s, or with the assassination of Rabin in 1995, or with the First Intifada in the late 1980s and early 1990s, or with the growth of the Israeli settlements in the West Bank in the 70s and 80s, or with the 1967 war when Israel took control of the West Bank and Gaza, or with the 1948 war when Israel declared independence and where more than 750,000 Palestinian Arabs were forcibly displaced or killed in the Nakba, or with the Jewish refugees fleeing Europe after the Holocaust, or with the immigration policies of post-World War I British Mandate Palestine, or with the Ottoman Empire, or with the emergence of Zionism in the swirling nationalism of Europe in the 19th century, or even earlier. And you may be familiar with some of this history, and each starting point has its merits, but would still be selective. There's no one history or way of telling it. Not all of these moments, however, are directly relevant to questions of international law. And this leads me to my second caveat. This talk is focused on international law and how it operates. I prepared it on the assumption that you aren't experts in international law, so apologies to those of you for whom this material will be familiar. And while I won't be focusing in this presentation on the specific factual allegations made against both Hamas and Israel on and since October 7th, please do not take this as suggesting that I do not recognise the horrors that have been experienced. It's been terrible to watch it unfold. Given this, and I think this is always important to remember when we talk about law, be aware that there's other frames that could be adopted and questions that might be important to ask about Israel and Palestine, but that would be a different conversation. So instead, my ambition today is to leave you with a better understanding of the key international legal issues at stake in the conflict between Israel and Palestine, and the relevance of the ICJ, the International Court of Justice, and the ICC, the International Criminal Court, to those legal issues. And with that in mind, I'll be addressing the key legal questions and frameworks in relation to Israel and Palestine, how the ICC and ICJ operate and the extent of their jurisdiction, how issues in Gaza and the rest of the occupied Palestinian territories have come before these courts, and the operation of some of the key legal principles and rules that are at issue in this context. In particular, the legal tests for designating a situation a genocide in international law and some war crimes and crimes against humanity that are potentially relevant in the current conflict in Gaza. As I will explain, there is a wide uniformity in how international lawyers understand the legal issues at stake in the conflict and the role that international legal institutions can have in responding to it. And I'll conclude with some reflections on what we might take from this about the operation of international law and how it operates. I'll also give you some opportunity to ask questions throughout, and I'm happy to take any questions you have at the end. All right, so let's start with a bit of framing. To begin, you should be aware that the ICJ and the ICC are very different institutions with very different ambitions. The International Court of Justice, the ICJ, is a court that settles disputes between states and delivers advisory opinions in response to questions asked by UN bodies. It is focused on how international law applies to states and the UN and its constitutive parts. The ICC does something very different. It determines the individual criminal responsibility of individuals for breaches of international law. It's about what certain people did. The ICC does not make findings about state responsibility. It's about whether the particular accused in the dock is guilty of a crime. While they have different ambitions, both courts must address a similar set of issues and questions when it comes to the situation in Palestine. And I think we can really organise them into three categories. We have firstly the status of the Palestinian territories. Second, the law that applies in those territories once we've identified the status. And thirdly, once we've got the law, then we can figure out whether that law has been complied with. As we'll discuss, these questions have been considered in depth by the ICJ and would be crucial to a case before the ICC. So the first question is identifying the legal status of the different territories, as this will determine what parts of international law apply to those territories. First, we have the internationally recognised sovereign state of Israel, which exists in the borders established by the 1949 Armistice Line, known as the Green Line, which includes West Jerusalem. The legal status of Israel as a state is not in any way controversial in international law. It has sovereign rights over its internationally recognised territory, including the right of self-defence. It's a member of the UN and is bound by customary international law and any other treaties that it has signed, including human rights law and international humanitarian law, the laws of war. Second, we have the Palestinian territories. This is what was left of the mandatory territory of Palestine after the 1948-49 war, and this includes the West Bank and Gaza. So on the map here, you can't see it that well, but the green line around the edge of the West Bank and Gaza, you might be able to see that. That's the green line that existed after the 1949 conflict. Whether territorial Palestine amounts to a state is a more contested question in international law. Palestine meets some of the criteria for statehood, including being a signatory to some important international treaties and is recognised as a permanent observer state at the UN. What it lacks, however, is universal recognition from other states as being a state. Of course, recognising Palestine as a state, if we were to follow this route, does not mean it has the same capacity to govern its territories as other states. And this is because Israel exercises military control over the West Bank, and since the invasion of Gaza late last year, really controls almost all of Gaza. So it's useful to say a little bit more about how the West Bank is governed. And so the map, this other map on the screen, which is somewhat obscured by the flags, it's a little complicated, but hopefully you can see that it's split into 3 zones. Area A, which is administered by the Palestinian Authority, this is the area in orange. Area B, which is shared between the Palestinian Authority and Israel, and then Area C, which is administered only by Israel. The geographical divisions in Palestine that you can see on the map demonstrate that the pockets of Palestinian population are like an archipelago in a sea of Israeli military and civilian control. And this is a deliberate strategy. It's a matter of record that the Israeli government has been officially pursuing a policy of promoting Israeli settlements in the West Bank through financial support, tax breaks, as well as through ensuring their security. The official settlements are connected to Israel by major highways, and as you might be able to see from the gaps in between the Palestinian population, operate to split up the population in the West Bank. There is also a wall that serves as a physical separation between the Palestinian population in the West Bank and Israel. However, this does not travel along the internationally recognised border, the Green Line, but carves a line between the Palestinian communities as well as through East Jerusalem, but all of the wall is on the Palestinian side of the 1949 Green Line. So Israel has obligations in general international law and human rights law that are relevant to the context of its control of the West Bank and of Gaza. And the key ones that we're going to touch on that relate to the right of self-determination of the Palestinian people and the prohibitions on genocide, apartheid and racial segregation. So turning to Gaza, the Israeli invasion of this territory means that it's quite clear now there's an active armed conflict and that the parties to that conflict must comply with international humanitarian law, which are the laws of war. These rules govern the conduct of hostilities. Israel and Hamas are both bound to follow them. Some of the rules are very important, and most significantly, IHL requires the parties to armed conflicts to respect the principle of distinction and ensure that they only attack military objectives, and to ensure that the harm to civilians caused by attacks is not disproportionate to the military advantage gained, and that all attacks are militarily necessary. There are also rules about what precautions need to be taken in an attack, how people who are captured are treated, and what sort of places, whether they're schools or hospitals, must be protected. Prior to last year's invasion by Israel, the legal status of Gaza was much more uncertain. Some people argued that Israel exercised such a high degree of control over Gaza that it amounted to occupied territory, which is a specific legal status in international law, but others were not convinced. So once we've established the status of the territories and identified the legal rules that apply, we can then assess whether these rules have been complied with. And so I think when we think about who these rules apply to, the obligations of international law bind both states, in this case Israel and possibly Palestine if we accept Palestine as a state, and in some cases individuals, so the leaders of Israel and Hamas in Gaza. And this means that when we think about the situation in Israel and Gaza and Palestine, we need to think about both state responsibility and individual criminal responsibility, but understand that they are different things. So let's recap what we've covered. As I said, there's sort of 3 categories of legal questions that we need to separate out. When we think about the questions at stake before the ICJ and ICC, we have the status of the territories in international law. We have the law that applies in those territories once we've identified their status. And once we've identified the law, we can then think about whether it's been complied with. So before we move on to the ICJ and ICC, does anyone have any questions they'd like to ask about the legal status any of the sort of material I've presented so far. Yeah.
The requirements to improve the military relevance of a target.
Yeah.
We're seeing that being quite blurred, and I know this is probably going to come out in the years that follow. But what is the burden of proof for parties to satisfy that criteria? Because it seems to be like they're certainly being flirted with or completely violated. So what do they need to do? A legitimate actor doing this, there's a picture of civilian, potentially military targets. How do they establish that they're actually satisfying international law?
Yeah, that's a great question, and it's hard to answer in the abstract because it's always a contextual judgment. I think there are a few things that you can say about it. First, it's an anticipatory judgment you have to make, so it's not about the consequences of your decision. If you just think an attack is going to be worthwhile and you end up, killing 50 children, but you weren't expecting that, then that's not a breach of international humanitarian law because of the terrible consequences of your choice. So it's always based on what the commander knew at the moment they made the decision to do the targeting, and then it's kind of a reasonableness standard. Where you would say, well, the commander, how much time pressure was there? Was it an emergency? How much time do they have to think? Was it practical for them to gain more information? And these are all questions of judgment that reasonable minds might disagree about. I'd say it's and very hard to say without knowing anything about the attack other than the consequences, whether or not it's lawful or unlawful. And perhaps you saw this in response to the killing of the Australian aid worker in Gaza a few months ago, or I think that was earlier this year, where there was hesitation amongst some people to say confidently that this was a war crime, because you don't know whether it's a war crime unless you know what information the commanders had when they made their decision. But these are all questions of judgment that you need to know much more about a specific attack. And you often also see a difference between what the military people think might be reasonable and then what other observers might think might be reasonable. So need a lot more information to be able to make a judgment. And that's, I think, a fair critique you could make about international humanitarian law as a body of law and how effective it is at promoting accountability for those sorts of decisions. Sue?
Just then, I'm trying. It's even more complicated because the Geneva Conventions say that you can't target civilian things, but you're also not allowed. So Hamas are not allowed to shield themselves with civilians. So that's the problem I think we're having. Is that you're not allowed to. So if you're a combatant, you're not allowed to hide inside a civilian hospital or a civilian school in order to carry out your operations. And if you do, you lose the protection of the civilian nature of that target. So I think that is a very complicated factor that's in this particular conflict. That's a question of fact. Right?
Absolutely. And I think that's why you can't say just because a hospital has been attacked that it's necessarily unlawful. That's not, you need to know whether or not there were military activities occurring in the hospital, which is what Israel has, what their response to this critique when it's come up. So we'll definitely have some more time for questions as we go through and at the end. So we're going to start first with the ICJ, the International Court of Justice. And so this is sometimes referred to as the World Court, the place where states can go for a legal determination of interstate disputes, and UN bodies can request advisory opinions about international law. And there's been 3 ICJ proceedings that have directly addressed the situation in Israel and Palestine. And the 3 proceedings are the legal consequences of the construction of a wall in the occupied Palestinian territory from 2004, known as the Wall Decision, and then one from this year, the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory. This particular decision is too new to have a tidy title for me, but let's call it the Policies and Practices of Israel advisory opinion. And the third one is the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, the South Africa and Israel case, which is ongoing. So you might notice already that there are 2 advisory opinions and 1 interstate dispute, and we're going to discover the distinction between these 2 different kinds of proceedings a little later in this talk. All right, so before we do this, let's step back and talk a bit about how the ICJ operates and the extent of its jurisdiction. So while the ICJ was created in the aftermath of World War II, it comes from a much longer history of interstate dispute settlement. And the building where it now resides, the Peace Palace in The Hague in the Netherlands, was built for the Permanent Court of Arbitration in the first decade of the 20th century, I think with money from Carnegie, yeah. The PCA was joined in the building in 1922 by the Permanent Court of International Justice, and in 1946 the ICJ replaced the Permanent Court when the UN replaced the League of Nations. This meant that when it came to designing the operation of a new world court, the drafters of the ICJ statute had a significant amount of experience to draw upon and ended up adopting much of how the Permanent Court had operated. But there was one significant difference, and that is the ICJ has a much closer relationship with the UN than the PCIJ did with the League of Nations. And this is evident from Chapter 14 of the UN Charter. In this chapter, Article 92 provides that the ICJ is the principal judicial organ of the United Nations and that the ICJ statute forms an integral part of the UN Charter. And a little bit further, Article 93 provides that all members of the United Nations are ipso facto parties to the statute of the ICJ. It is the ICJ statute, a separate document of 70 articles that is annexed to the UN Charter that provides the details for how the court operates. And the statute, the ICJ statute, is organised into 5 parts. Chapter 1 sets out the organisation of the court. Chapter 2 addresses the competence of the court, that is, its jurisdiction. Chapter 3 sets out court procedure. Chapter 4 sets out the rules relating to advisory opinions. And Chapter 5 sets out the process for amendments. We won't be going through all of these parts. You'll probably be relieved to hear, but there are a few things that I'd like to draw to your attention. And let's start with who sits on the court. So it's a big court. Article 3 provides that the court will have 15 members, most of whom will sit on most cases. So for comparison, the Australian High Court has 7 members and the US Supreme Court has 9. So 15 it's a big one. These 15 members are elected to 9-year terms, with 5 elected every 3 years, and a judge can be re-elected for further terms. The statute ensures that the court has an international character, and you can see this from Chapter 3, which provides that no 2 judges may be nationals of the same state. And Article 9 provides that the electors must remember that in the body as a whole, the representation of the main forms of civilization and of the principal legal systems of the world should be assured. The elections of the judges take place by simultaneous voting in the Security Council and the General Assembly of the UN, and candidates have to receive an absolute majority in both organs of the UN. The results of these elections reflect political alliances and great power politics, with the 5 permanent members of the Security Council generally having a judge on the court. Notwithstanding the election process, the statute guards the judicial independence of judges, and Article 2 provides that these 15 people must be independent judges of high moral character who possess the qualifications required in their respective countries for appointment to the highest judicial officers or a jurisconsults of recognised competence in international law. So this could include lawyers, academics, national or international judges, as well as diplomats with international law experience. Along with these 15 judges, Article 31 provides that a party to a case has something like a right to representation by a national judge. If there's no national judge on the court, the state can appoint a judge ad hoc who may be of another nationality. While we can expect the judge ad hoc will take the side of their state in the proceedings, they still have all the obligations for judicial independence as the other judges, so they might not take the side of the state. Now that we know how the judges of the court are chosen, let's turn to its jurisdiction. The ICJ has 2 forms of jurisdiction, that over contentious cases and the advisory jurisdiction, and each should be considered separately. So Article 36 of the statute makes it clear that the court's jurisdiction over contentious cases depends on the consent of the parties. Sometimes a state might consent to resolve a specific legal issue or give advance consent in a treaty to resolve all issues about the treaty through the ICJ, or even give their advance consent always to resolve legal disputes at the ICJ. Contentious cases can take a very long time to hear and decide. Proceedings have two parts. They have a written part and an oral part. So the parties first have to submit written submissions, and then there might be replies and rejoinders. And after this, there's oral proceedings, which can involve the calling of witnesses. In the end, final judgment can be delivered many years after the case was commenced. So this is a long time that ICJ proceedings take. But during this time, there can be incidental proceedings that can impact the legal rights and obligations of the parties. And one in particular is important for our purposes, which is interim proceedings to secure provisional measures of protection. And so for those of you with some sort of experience with domestic legal systems, you could think of this like an injunction, a moment before the trial or the proceeding has been resolved, where the parties try to hold the situation in place. So Article 41 of the ICJ statute provides that the court has the power to make provisional measures to preserve the respective rights of either party pending the final decision. So while the language of the statute says the court should indicate, which perhaps implies a discretion in whether to comply with the provisional measure, the court has found in cases that provisional measures are binding on the parties as a matter of international law. So you might breach international law by breaching the provisional measures, even if you win the case in the end. Ordering provisional measures is not deciding the case. The court does not have to be fully satisfied that it has jurisdiction or that a wrong has been committed, as long as there's a prima facie case. So the standard is lower for provisional measures. Of the three ICJ cases relating to Israel and Palestine, only one is contentious, and this is the application of the Convention of the Prevention and Punishment of Genocide in Gaza, the South Africa and Israel case. I'll just call that the South Africa and Israel case from now on. So you might ask why, given state consent is so critical, Israel consented to have a case determined by the ICJ in the midst of the war in Gaza. And the answer is that they gave it in advance by signing up to the Genocide Convention. In particular, Article 9 of this convention provides that disputes between parties to the convention relating to the interpretation, application or fulfilment of the present convention, including those relating to the responsibility of a state to genocide, shall be submitted to the ICJ at the request of any of the parties to the dispute. So this is a clause which requires that the resolutions of dispute about the Genocide Convention should be dealt with by the ICJ, which is why we've seen several genocide cases before the court in the last few years, not just in relation to Israel and Gaza, but also in relation to the situations in Myanmar and Ukraine. All right, the other form of jurisdiction of the ICJ is known as the advisory jurisdiction. So let's turn to that now and start by setting the limits of this jurisdiction. So Article 65(1) provides that the court may give an advisory opinion on any legal question at the request of whatever body may be authorised by or in accordance with the Charter to make such a request. So Article 96 of the UN Charter provides that the General Assembly and the Security Council can request an opinion of the court if they want to, and the Assembly can allow other UN organs and institutions to also request opinions. So what this advisory opinion function allows for is for the UN and its agencies to seek authoritative guidance about any legal questions that come up in relation to their functions or other activities. This can relate to sort of really general or abstract questions, like there was a case about the legality of nuclear weapons, or it can be really specific, such as about how a particular dispute or situation and how the legality of that dispute or situation impacts on the exercises of the UN. This section, Article 65 and Article 96, clearly allow the court to consider a wide range of issues, some of which might be very politically contentious. And some states have objected to advisory opinions on the basis that it's outside of the scope of the court's jurisdiction in Article 65 to deal with political questions. The court, however, has taken a really broad view of what amounts to legal questions. And in the 2010 advisory opinion in relation to the unilateral declaration of independence in respect of Kosovo, the court explained that the court has repeatedly stated that the fact that a question has political aspects does not suffice to deprive it of its character as a legal question. Whatever its political aspects, the court cannot refuse to respond to the legal elements of a question which invites it to discharge an essentially judicial task, namely, in the present case, an assessment of an act by reference to international law. The court has also made it clear that in determining the jurisdictional issue of whether it is confronted with a legal question, it is not concerned with the political nature of the motives which may have inspired the request or the political implications which its opinion might have. So the advisory opinions of the ICJ are authoritative statements of international law. They are highly persuasive, but of course it's possible for states to reject them and refuse to comply with their findings. Enforcement would rely on the Security Council taking action, which is something very hard to achieve given the veto power of the major powers. Before we start talking about Israel and Palestine and the ICJ cases, any quick questions on the way the ICJ is set up? So let's turn now to these three cases that I've mentioned now that we've got a really strong idea, hopefully, of the difference between the advisory opinion jurisdiction and contentious cases. So we've got these three cases. We've got the Wall decision, the Wall advisory opinion, the opinion in relation to the policies and practices of Israel, and then the South Africa and Israel case. So we'll look at each of them in turn. So the legal consequences of the construction of a wall in the occupied Palestinian territory concern the legality of the separation barrier in occupied Palestine. And as I noted earlier, the barrier doesn't travel along the Green Line, the 1949 border, but inside Palestinian territory. And it has a substantial impact on the ability of people, mainly Palestinian, to move, particularly between the parts of East Jerusalem on the Israel side of the wall and those on the outside of the wall. Israel claimed that the wall was necessary for reasons of self-defense in response to threats of terrorism during the Second Intifada. So in response to the construction of the wall, the General Assembly had asked the court to consider, this is the question that the GA put to the court, what are the legal questions arising from the construction of the wall being built by Israel, the occupying power in the occupied Palestinian territories, including in and around East Jerusalem, considering the rules and principles of international law? So in answering this question, the court found 14-1. So the court, 15 members, but they don't all have to decide the same thing. You can have dissenting judgments. That the construction of the wall was not in compliance with Israel's obligations in international law. There are many interesting features of this judgment that we could examine. It's an example of the advisory opinion of the ICJ being used to bring a really contentious issue of international law before the court without the consent of one of the parties, one of the states involved, and without the consent of the Security Council. It also demonstrates that the court sometimes has to deal with really complex factual matters, although in this case, Israel declined to present any evidence to the court to support their contention, and the court made its decision on more abstract grounds. However, I do want to focus on three aspects of the decision. First, what the case tells us about the law applicable in the West Bank, the extent of the right to self-defense to threats emerging from occupied territory, and a little bit about the obligations of occupation law. So first, the court made it quite clear that the West Bank was occupied territory. And this was an important finding. Israel had claimed that as there was no legitimate sovereign of the West Bank prior to the 1967 war, I think this is still the legal theory that the Israeli government operates under. They said it was controlled by Jordan, but not recognised as part of Jordanian territory. So it didn't have a legitimate sovereign. Which meant that they said that due to that lack of a legitimate sovereign and the formal agreement that they'd made with the PLO, the Palestinian Liberation Organization, for the government of the West Bank, the rules relating to occupation did not apply. The reason why Israel's very focused on the laws of occupation, obviously it sets a framework for how they have to govern occupied territory, but there's a particular prohibition in the rules of occupation relating to the transfer of population in Article 49.6 of the Fourth Geneva Convention, and this is the particular international law obligation that Israel's keen to say doesn't apply to the West Bank, because if that applies, the settlements are unlawful. So this was rejected by the court in paragraph 78 of its judgment, and the court said that it would observe that under customary international law, territory is considered occupied when it's actually placed under the authority of the hostile army, and the occupation extends only to the territory where such authority has been established and can be exercised. The territory situated between the Green Line and the former eastern boundary of Palestine under the mandate were occupied by Israel in 1967 during the armed conflict between Israel and Jordan, and under customary international law, these are therefore occupied territories which Israel has the status of occupying power, and nothing since then has altered this situation, which means that all of the territories, including East Jerusalem, are occupied territories. So that means that to this day, the IDF remains the occupying power in the West Bank and bound by the requirements of occupation law. So having decided it was occupied territory and that the Fourth Geneva Convention applied, the court went on to assess the legality of the wall under this framework. And it found that protecting the Israeli settlements in the West Bank was not a viable justification for the wall, as the settlements themselves were unlawful. And the court also found that the wall breached the human rights of the Palestinian population, including the right to movement and the economic rights related to resources. So it held in paragraph 137 that from the material available to it, it wasn't convinced that the specific course Israel had chosen for the wall was necessary to attain its security objectives, and that it gravely infringed a number of rights of Palestinians, and that these infringements couldn't be justified by military exigencies or by the requirements of national security. And so therefore it was a breach of international humanitarian law and human rights instruments. So lastly, the court dealt with an argument related to self-defense. And Israel had argued that it had a right to build the wall as per self-defense in Article 51 of the UN Charter. So what they were arguing was that they had a legal right to defend themselves against the threat of terrorism emanating from the territory that they occupied. And the court rejected this view. They said that as the threat emerged from territory under the control of Israel and from a non-state group, it did not trigger this right to self-defense in Article 51. Instead, it held that the appropriate frame for assessing legality was occupation law, not this other set of law and self-defense. So having so found, the court decided, as I said, 14-1, that Israel was under an obligation to stop the violations of international law and to dismantle the wall, and that all states are under an obligation not to recognise the illegal situation resulting from the construction of the wall and not to render assistance to maintain the situation. Of course, as you're probably aware, Israel continued building the wall, and it's more extensive than it was in 2004. So moving on to our second case, which is much more recent, so 20 years after the wall advisory opinion, and covers some of the same ground. And this is the legal consequences arising from the policies and practices of Israel. And so this case was in response to a request made by the General Assembly in 2022. And the Assembly asked, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement and annexation of Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character and status of the territories, and from its adoption of related discriminatory legislation. And it said the other question it asked was how the policies and practices of Israel affect the legal status of the occupation, and what are the legal consequences that arise for other states. So in response to these questions, a very strong majority of the ICJ concluded that Israel's continued occupation of the occupied Palestinian territories breached various rules of international law, and that as such, Israel had to withdraw from the territory as rapidly as possible. And these breaches included the construction of settlements, the failure to prevent violence by settlers, and the failure to respect the human rights of Palestinian people and their right to self-determination. For an international lawyer, these conclusions are really unsurprising. In the words of prominent professor of international law, Marko Milanovic, some of these practices are so blatantly illegal that no reasonable international lawyer could argue otherwise. Again, there are many aspects of this advisory opinion that are worthy of close analysis, but I'll just address a couple that I think are of particular importance. First, the court's finding that the occupation itself was unlawful and had to be terminated was very significant. It went beyond merely declaring that certain practices of the occupying power were unlawful and instead said the whole thing was unlawful. So if you think about occupation law sets a series of rules about how territory should be governed. You might be in breach of some of them, but not be in breach of all of them. And saying you're in breach of some doesn't mean the whole thing is unlawful. Whereas what the court was saying is the whole thing was indeed unlawful. And the majority of the court held that while the prolonged nature of Israel's occupation did not change its status under international humanitarian law, as IHL doesn't depend on the legality of the conflict. So I'll just pause here because I think this subtlety is hard to grasp when you first read it. Starting an illegal war doesn't mean that how you fight the war itself is unlawful. So to give an example, with the invasion of Iraq of the US in 2003, you might think that the invasion itself was unlawful, but yet then looking at specific US activities in Iraq in 2003, you'd have to assess them according to the rules of IHL. So an initial illegality doesn't taint all of the decisions made in the conflict from the side of IHL, or the Russia-Ukraine example would be another one. The fact that Russia's invasion is quite obviously unlawful under international law doesn't mean that every attack Russia carries out in Ukraine is unlawful as a matter of IHL. I'm not saying that's the only way to think about it, and an attack being unlawful means that it's okay, but I think this is just how international humanitarian law works, which is it's about conduct that occurs within hostilities, not about why hostilities begun. So thinking about what the court decided, it said that that while the prolonged nature of Israel's occupation did not change its status, as I said, it did have an impact on its compliance with other areas or other rules of international law. So it wasn't Israel's occupation isn't a breach of occupation law because it's gone on for so long, but what it is it's a breach of the prohibition on the acquisition of territory resulting from the threat or use of force, as well as the right of self-determination. So Israel's in breach of these obligations, and as such, the court said it had to end its occupation as rapidly as possible, is the phrase the court used. And so this would include evacuating all the settlers. And so the court explained, the court considers that the violations by Israel of the prohibition of the acquisition of territory by force and of the Palestinian people's right to self-determination have a direct impact on the legality of the continued presence of Israel as an occupying power, and the sustained abuse by Israel of its position as an occupying power through annexation and an assertion of permanent control over occupied Palestinian territories and continued frustration of the right to self-determination violates fundamental principles of international law and renders Israel's presence unlawful. I think this conclusion was perhaps further than we might have expected the ICJ to go in this case. So I think it demonstrates just how clear things are in international law when it comes to Israel and Palestine. Second, the majority of the court held that Israeli policies in the West Bank amounted to racial discrimination without proper justification. And so it held at paragraph 229 that the court observes that Israel's legislation and measures impose and serve to maintain a near complete separation in the West Bank and East Jerusalem between the settler and Palestinian communities. For this reason, the court considers that Israel's legislation and measures constitute a breach of Article 3 of the Convention on the Elimination of All Forms of Racial Discrimination. So you might think, well, what's the significance of this? Let's look at Article 3 of the Convention on the Elimination of Racial Discrimination. It provides that state parties condemn racial segregation and apartheid and undertake to prevent, prohibit and eradicate all practices of this nature. And so what this means is that according to the ICJ, Israel's policies in the West Bank either amount to racial segregation or apartheid. And the court didn't say which one they thought it was. And the reason they wouldn't have said which one thought it was to try to maintain a majority amongst the members of the court. If they'd picked one over the other, you would have had that majority splitting. So the difference between apartheid and racial segregation is intent. Article 2 of the International Convention on the Suppression and Punishment of the Crime of Apartheid defines apartheid as inhuman acts committed for the purpose of establishing and maintaining domination by one racial group of persons over any other racial group of persons by systematically oppressing them. So it's this intent. And as we'll discuss in relation to genocide, proving the intent behind a particular policy or action can be really challenging. So the two advisory opinions that we've talked about demonstrate that Israel is in systematic violation of its international obligations as an occupying power in the occupied Palestinian territories in the West Bank. I think it also demonstrates that this conclusion isn't controversial in international law, which is really evident from the strong majorities that you can see in both cases. So the final ICJ proceeding that I'll talk about is the application of the Convention of the genocide case between South Africa and Israel, which started in December 2023. And this is a photo from that proceedings. Not that I was there, this is from the ICJ website. The case is yet to be finally determined, but it will probably take several years to complete. Well, it will take several years to complete. South Africa instituted proceedings in response to acts that it said in its application threatened, adopted, condoned and being taken by Israel against the Palestinian people, and that this risked amounting to genocide. South Africa's application, using the language of the Genocide Convention, stated that, and I quote, "The acts and omissions by Israel complained of by South Africa are genocidal in character, because they are intended to bring about the destruction of a substantial part of the Palestinian national, racial and ethnical group, that being the part of the Palestinian group in the Gaza Strip." And these acts included the killing of Palestinians in Gaza, causing them serious bodily and mental harm, and inflicting on them the conditions of life calculated to bring about their physical destruction. So these are words taken directly from the Genocide Convention. South Africa referred to repeated statements by Israeli state representatives, including at the highest levels by the Israeli president, the prime minister and the minister of defence, which it said demonstrated or expressed genocidal intent. Israel rejected these allegations with disgust, arguing that its activities in Gaza are in accordance with IHL and that Israel was targeting Hamas, not the civilians of Gaza. The urgency of the situation led South Africa to request an expedited hearing for the court to consider indicating provisional measures to protect the rights involved from imminent and irreparable loss, including for Israel to immediately suspend its military operations in and against Gaza. And I'm sure you would have seen this reported in the news. Unlike the advisory opinions, Israel is being a participant in this proceedings and has been represented before the court by some very esteemed international lawyers, and has also appointed an ad hoc judge. So let's pause for a moment to consider what would be necessary in order for South Africa to succeed in its case. The definition of genocide in international law is perhaps narrower than you might expect. It comprises of a list of acts that must be committed with the intent to destroy in whole or in part a national, ethnical, racial or religious group, which can include a series of different actions. So it requires two things to be proven. You have to prove that one of these things has occurred, but also, and this is the hard bit, that it's done with the intent to destroy a protected group in whole or in part. So this is extremely difficult to prove. It's not enough to show that Israel was careless with Palestinian lives, or even that it committed war crimes. That wouldn't be enough. The killing must have been done with the intent to bring about the destruction of the Palestinian people, not in self-defense or for security reasons. And while there are some indications of genocidal intent, there are plenty of other rationales, acceptable or unacceptable, that for the war in Gaza that don't meet the criteria for genocide. So I think it's definitely a conceivable outcome that South Africa ultimately loses this case if they can't prove this really high level of intent. There's also dispute or there's some international law debate about whether or not the genocidal intent has to be the only intent or whether it can be sort of one aim amongst others, which I don't think has been resolved as a matter of law. And clearly in this situation, if it was necessary to prove that Israel's only intent in going into Gaza was to commit genocide, I think that would be a difficult argument for South Africa to win. So there have been several requests of South Africa for provisional measures. And you might remember from earlier on, provisional measures are sort of like this injunction stage, this preliminary order that the court makes. And so the purpose of these orders is to maintain the rights of the parties. It doesn't tell us what the ultimate outcome of the case will be, and the tests that are applied in this stage of the proceedings are easier for the applicant to satisfy. So it's important to remember that the ICJ hasn't yet decided whether Israel's conduct in Gaza amounts to genocide. It has, however, made a series of provisional measures. And in order to grant a provisional measure, the ICJ must be satisfied that the case is plausible, that is, has a realistic prospect that the rights will be judged to exist and be applicable. South Africa has not proven that Israel has committed genocide. All that we can say is the ICJ has found that the South African case is plausible, which is, still not nothing. The provisional measures that the court has made have become more direct as Israel's continued to fail to comply with them. So in January, the court required Israel to, among other things, take immediate and effective measures to enable the provision of urgently needed basic services to Gaza. And in March, the court made it more specific, requiring Israel to take all necessary and effective measures to ensure the unhindered provision at scale of urgently needed basic services and humanitarian assistance, including food, water, electricity, fuel, shelter, clothing, hygiene and sanitation requirements. And in its most recent decision in May, the court said the humanitarian situation in Gaza was now to be characterised as disastrous, and as such, Israel must immediately halt its military offensive and any other action in the Rafah governorate, which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction. So the events since May demonstrate that Israel has not complied with these orders. It's continued its military offensive, and the humanitarian situation in Gaza has continued to be disastrous and is getting worse. So we could have a situation where Israel wins the genocide case, but is in breach of its international legal obligations by failing to comply with the provisional orders. So Israel and the ICJ, what's the point? Clearly, things haven't gone Israel's way at the ICJ in the three proceedings that have concerned its activities in the West Bank and Gaza, and the strong majorities in each of these cases demonstrate that the way international law applies in each of them is relatively clear. It's also evident that Israel has failed to comply with the decisions of the ICJ, and notwithstanding the 2004 wall decision, the barrier continued to be built. It's very hard to imagine Israel withdrawing from the West Bank and ending its occupation in response to the advisory opinion of this year, and the provisional measures ordered by the court in the Gaza proceedings have not been complied with. There's nothing the ICJ itself can do about Israel's failure to comply with its decisions. It does, however, demonstrate that Israel persistently breaches its international law obligations in relation to Palestine and continues as a matter of law to be responsible as a state for those breaches. So I think at the end we'll perhaps have some reflections on what to think about international law given this failure of Israel to comply. Something to reflect on. All right, in the interest of time, I'm going to move straight on to the ICC, which is this building you can see on the screen. So like the ICJ, I'm going to say something about how the ICC set up before moving on to its relevance to the Israel-Palestine situation. So the ICC is a much more recent institution than the ICJ. The Rome Statute, the agreement establishing the court, was agreed in 1998. It was only 4 years later, in 2002, that enough states had ratified the treaty for it to enter into force. Currently, there's 124 state parties, which include Australia. So the ICC is focused on criminal responsibility. That is, the responsibility of individuals for crimes enumerated in the Rome Statute. As such, while it's built off some of the same law as that relating to state responsibility that we've been discussing from IHL, the Genocide Convention and human rights law, it has a different form, it asks different questions and has different standards of proof. Focusing on individual responsibility is a major departure from the traditional conception of who international law applies to. So criminal law aims to hold individuals to account for their actions. Criminal responsibility is much more complex for international crimes than it is for domestic crimes, and that's because the individualisation of criminal law contrasts with the often the very collective nature of violence, and this is a critique that's sometimes made of international criminal law. And we can see this very clearly in the situation of Israel and Palestine. So the jurisdiction of the court, it covers a significant portion of the world. And so all the states in green on this map are state parties to the UN. Sorry, not to the UN, to the ICC. All member states are part of what's called the Assembly of States Parties, the ASP. And this group meets regularly to decide on the budget for the court, to elect judges and to elect the prosecutor. There is also a mechanism that allows the ASP to amend the statute and to make new crimes. So green are the ones that have signed up. Yellow are the states that have signed the treaty but haven't ratified it. So they're not members of the Assembly of the State Parties, but they are at the Rome Conference. And they sort of have a different kind of relationship. So there are very few powerful states. There are a few very powerful states that have not signed up, which you can see most significantly Russia, China, the US and India, which is, I guess, the bulk of the world's population. This is important as the ICC doesn't have universal jurisdiction, but only jurisdiction over the nationals of a state party, the territory of a state party, or due to referral by a third state of itself, or by referral by the Security Council. The jurisdiction of the court is also limited in time, so it's prospective and only applies to crimes that occur after jurisdiction commences. So only on the 1st of July 2002 for states that were part of the Rome Statute from the beginning, or the entry of the force of the Rome Statute for that particular state. So if Indonesia was to join up next week, the jurisdiction would start in Indonesia next week. You wouldn't be able to go back to past events. All right. So the structure of the ICC is similar to other courts. It has three organs. We have the judges, the office of the prosecutor, and the registry. The judges are further divided into the appeals division, the trial division, and the pre-trial division. Each of these three organs are independent. The judges are responsible for deciding cases. The prosecutor is responsible for prosecutorial decisions and execution, and the registry is responsible for the non-judicial aspects of court administration. The pre-trial division, which isn't on this screen, is sort of in the chambers part, I suppose you'd say, is responsible for matters that arise before the trial begins, such as those relating to jurisdiction, admissibility, and arrest warrants. The trial divisions runs the trials, and the appeals chambers hears any appeals. The statute provides for 18 judges who are elected from a list of persons nominated by the state parties, and the rules for election of the judges are quite complicated, with a requirement for judges with expertise in international law, a group of judges with expertise in criminal law, and with an equitable regional distribution and gender balance. Where the jurisdiction of the court has been triggered, it can try accused persons for the four core crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. The statute sets out the detail of these crimes, and the Assembly of State Parties has provided further explanation of how they operate in a document called the Elements of the Crimes. And this Elements of the Crimes is like a subsidiary document that operates as an aid to interpreting the statute. So you can think of this like an explanatory memorandum in the domestic legal context. Three of these core crimes, genocide, crimes against humanity, and war crimes, are particularly relevant to the situation in Palestine. So genocide is defined in Article 6 of the Rome Statute, and you might be able to recognise follows verbatim the definition of genocide in the Genocide Convention. It's a difficult crime to prove. Like the test for state responsibility, it requires specific intent to commit genocide as opposed to carrying out an act for some other reason. Crimes against humanity are defined in Article 7 of the Rome Statute, part of which you can see on the slide. It's too big for me to represent in this form. And so it presents a list of individual crimes like apartheid, murder, rape, enslavement, torture, enforced disappearance. But doing a single act by itself isn't enough. In order to fall under the crimes against humanity provision, the individual act must be committed as part of a widespread or systematic attack directed against any civilian population with the knowledge of the attack. So it has to be widespread or systematic in order to be a crime against humanity. War crimes in Article 8 are where ICL, International Criminal Law, and IHL meet, and they basically consist of serious violations of IHL. Although these are partly distinct legal regimes, the law of armed conflict has been shaped through adjudication by ICL tribunals, and the judgment of the tribunals sometimes offer extensive analysis of what is permitted and prohibited by IHL. And so thinking of the question you were asking before about what measures to take in attacks before you do it, I think there's some jurisprudence from the ICTY that discusses a couple of attacks and the measures that were taken, although those decisions were quite controversial amongst military observers of those decisions. So war crimes are found in Article 8. They're divided, like the underlying source material in IHL, into two different sorts. There's crimes committed in an international armed conflict and crimes committed in a non-international armed conflict. There's a much wider list of crimes in an international armed conflict that can be committed. The rules in non-international armed conflicts are much slighter because states wouldn't agree to tie their hands in a civil war, basically. The crimes said that the international armed conflicts are conflicts occurring between two states. Non-international armed conflicts are all other conflicts, but generally occur between states and non-state armed groups. So classically, your civil war situation. This means when we're trying to figure out what war crimes potentially apply, we have to ask two questions. First, is there an armed conflict? And second, if we do have an armed conflict, what sort of armed conflict is it? If it's an international armed conflict, one set of rules apply. If it's a non-international armed conflict, a smaller set of rules apply. In some cases, such as a war between two states, this is very straightforward. So Russia and Ukraine, simple to characterise. It's definitely an international armed conflict. However, in other cases, characterisation is more challenging. And international criminal tribunals have been faced with situations where one state's acting through a proxy non-state armed group in a quasi-civil war, or where there are international and non-international armed conflicts occurring in different parts of the same state, or where there is low-level sporadic violence, and it's unclear whether it passes the threshold for armed conflict. And the Gazan conflict has some features which make characterisation difficult. And the Hamas is a non-state armed group. It's not sort of a recognised representative of Palestine. And so it's unclear whether that would be a non-international armed conflict or an international armed conflict. The last crime in the statute, the crime of aggression, was added by amendment in 2010. So not all state parties to the Rome Statute have agreed to this amendment. So it doesn't apply in all of the state parties, but for some of them. And it's not really directly relevant for to the case in Palestine, but we can.
Shouldn't there be rules about invading other countries? Yes. This is a rule about invading other countries. Not meant to.
And I'll leave. We can return to aggression. There's lots of interesting things to say about aggression. So thinking about the ICC, Israel and Palestine. So there's, again, lots that could be said in relation to this topic. So instead of just focus on a few important moments and then look at the arrest warrants that have been sought by the prosecutor in relation to the situation in Gaza. So Palestine accepted the jurisdiction of the ICC over crimes occurring in its territory in 2015, with the statute entering into force in Palestinian territory in April of that year. The prosecutor announced in December 2019 that it would be commencing an investigation into Palestine, but sought a ruling from the pre-trial chamber about the extent of the ICC's jurisdiction. And the reason why they wanted to do that was because this was a question of Palestinian statehood. If Palestine wasn't a state for the purposes of the ICC statute, then the the rules wouldn't apply to it because it wouldn't be able to sort of fulfil some of the requirements for jurisdiction. However, in 2021, the pre-trial chamber handed down its decision, finding by majority 2-1 that the territorial jurisdiction of the situation in Palestine extended to the territories occupied by Israel since 1967. So that green line is the line that matters in international law. So this order by the pre-trial chamber meant that the prosecutor's investigation into Israeli conduct in the Palestinian territories continued. What exactly was being investigated is unclear, but it would be any acts or omissions conducted by Israel from April 2015. All right. So clearly the situation changed radically with October 7th and with Hamas's attacks on civilians in Israel. And in May 2024, 20th of May of this year, the prosecutor requested arrest warrants against the leaders of both Hamas and Israel for several different crimes. There's too many for us to cover in detail, but to give you a sense of what's in there, the prosecutor sought arrest warrants for the leaders of Hamas, Yahya Sinwar, Mohammed Diab, Ibrahim al-Mazri and Ismail Haniyeh, both for war crimes and crimes against humanity, including extermination, murder, the taking of hostages, rape and other acts of sexual violence and torture. And you can see the full list of allegations on the slide. So some of these will have occurred on October the 7th themselves, but they might have occurred at other times in the conflict. At the same time, the prosecutor sought arrest warrants for Benjamin Netanyahu, the Prime Minister of Israel, and Yoav Gallant, the Minister of Defense, for war crimes and crimes against humanity. And the alleged crimes include willful killing, intentionally directing attacks against civilians and extermination. But I think perhaps the most significant crime is, given the scale of it, is the allegation of using starvation of civilians as a method of warfare. So the process from here, the ICC arrest warrants are issued by a 3-judge pre-trial chamber at the ICC, and the prosecutor has to persuade them that there are reasonable grounds to believe a crime has been committed and that arrest is necessary. There will be a hearing, there will be evidence brought before the court, and the judges will consider whether the threshold for arrest has been met. None of the people which arrest warrants have been sought are currently in custody, and it's frankly hard to imagine, at least in the short term, that they will come within the custody of the court. As the ICC doesn't conduct trials in absentia, so without the presence of the accused, the proceedings won't be able to continue unless they have an accused. Nevertheless, the investigations will continue. The arrest warrants will have an effect in that they'll make it much more difficult for those charged to travel, because any of the 124 state parties to the Rome Statute can be requested to arrest a person who is subjected to an arrest warrant. So if you had a Israeli Prime Minister was to try to visit Australia, it would be a very difficult position for the Attorney General, who would have to decide, given how the Australian war crimes legislation works, whether or not to allow arrest of Netanyahu. So I think it basically would make it implausible that Netanyahu would come here. I think it would be too politically fraught, definitely under the current government. Maybe under a different government you'd see something else. But you might remember in relation to South Africa, there was the Sudanese leader who travelled there, and that caused a flurry of legal activity because South Africa was under an obligation to arrest him. And it definitely seems to have curtailed Putin's travel as well since the arrest warrants. So there are two things to note. First, about how the prosecutor characterised the conflict in Gaza, and second, the war crime of using starvation as a method of warfare. So as I mentioned before, the characterisation of the conflict is important as it determines what war crimes can have been committed. So we address that. And in particular, this war crime of using starvation as a method of warfare is only a war crime in international armed conflicts. So it's not a war crime to the as a method of warfare against your own population. Discovering some of the limits of international law here. The prosecutor explained in his statements that he considered there to be a non-international armed conflict between Israel and Hamas and an international armed conflict between Israel and the state of Palestine that commenced when Israel's armed forces entered Palestinian territory. The basis for this conclusion is a little unclear, but it could either be on the basis of a lack of consent by the Palestinian state to Israeli military incursion, or on the basis of the laws of occupation. If the pretrial chamber accepts that it's an international armed conflict, then it will be able to use this starvation as a method of warfare. It will be applicable. So this crime requires the prosecutor to prove several things. Elements 3 and 4 are really contextual elements that we can leave aside for the moment. The first two are the really critical ones, which are that the perpetrator deprived civilians of objects indispensable to their survival, and it did so intending to starve civilians as a method of warfare. So in Gaza, there's no question that the first element would be met. That would be easy to satisfy, but it's the second intent element that could be potentially difficult. But as Professor Douglas Guilfoyle from UNSW Canberra has pointed out, there are some strong indications that it will be possible to infer intent, such as the plainly inadequate number of aid trucks allowed into Gaza, the failure to implement the ICJ provisional measures, failure to act against Israeli settlements who block aid trucks, government ministers calling for a complete siege, and the fact that starvation follows from Israel's military strategy as a matter of course. So proving the requisite intent for this crime would be much easier than proving the specific intent required for genocide or apartheid. I think that there's a strategic reason why the prosecutor would choose this particular charge rather than perhaps some of the more high-profile charges that we might imagine are potentially being charged ultimately. But the prosecutor can add more charges as evidence is collected. So if they were able to demonstrate, for instance, genocidal intent, then you could imagine additional charges being laid. So I'm
For our students,
yeah.
well, oh my God, Susan, oh my God, Simon. Why are we studying this subject?
Yeah, so I think we've covered a lot of ground today. We've looked at the key legal questions in relation to Israel and Palestine, the operation of the ICJ and some of the cases from the ICJ, or all of the cases in the ICJ related to Israel and Palestine. And we also touched on the ICC and Israel and Palestine. So what I've presented to you demonstrates that in international legal circles, the legal characterization of Israel's conduct in Palestine isn't really controversial. Most lawyers agree that Israel's currently in breach, probably flagrant breach, of its legal obligations and has been in breach for many decades across multiple conflicts. While there are a variety of views about whether the intent requirements for some of the most serious international crimes, such as the crime of apartheid and genocide, are met in this context. So there is some debate amongst international law circles about whether those intent requirements are met. I think they will reach a point where the conduct is so apparent for so long that it becomes more possible to infer intent. Despite the clarity in how international law has applied, it's clearly not stopped Israel's conduct. It's continued to occupy the West Bank and appears to be continuing with a policy of de facto annexation of this territory. And the war in Gaza has continued without adequate provision made to civilians who are there. So, what's the point of international law? It's a question that I think everyone who thinks about international law asks themselves some of the time. I think it gives the international community a language to describe and to call out this behaviour. It allows for the community to put pressure on Israel to change its behaviour. And we can see these moves taken in international legal institutions, the ICJ and ICC, as part of that. And I think we are also seeing a change in perhaps domestic politics in relation to Israel and Palestine, and it would really require some of those supporting states to be more robust in their relationships with Israel for these policies to change. But you are perhaps seeing that with the European Union. There are some states in the EU who seem to be taking a different approach when it comes to Israel. And it's not inconceivable that if this behaviour continues, these policies continue, which to be frank, probably seems likely given what Israeli politics is like, that eventually states like Australia and the US will find it more difficult to support Israel. Any questions or thoughts that people have? Yeah.
I think we said before about proving the intent by Israel, but I would have thought that as we've seen in the ICJ, the warrants that particularly Netanyahu and Galant, who are tried murders controlling the Israeli government, they've expressed views which are really quite clearly negative, to say the least. And then you look at the riffraff in the desert and supporters of the government who've said basically kill them.
Mhm.
So I would have thought that I don't see how the intent is so hard to show. Not in the case overall, but still a difficult case, but the intent is very clearly there.
Yeah, so good question. I think there's like a legal question that you'd need to resolve about whether or not it has to be the only intent for carrying out an action. So if the international legal position that the ICJ or the ICC arrives at is that it's only genocide if the only reason you're doing the thing is to commit genocide, which let's just pull up that the part of the Genocide Convention. So if the only reason you're doing these things, if it has to be done with genocidal intent, then I think in the Gaza situation, there are other reasons why Israel wants to intervene in Gaza for their security reasons. And you might say, well, they might be committing war crimes, they might be committing crimes against humanity, but it might not be that the only reason they're doing that is to destroy in whole or in part a national, ethnic, or racial or religious group. But let's say you answer that question that it can be one intent among others, which would be a broader view of what would amount to genocide. I think that if you'd say, well, that's sort of rhetoric. It's not really. That's not why they're doing it. They're sort of speaking metaphorically. I agree. I wouldn't be particularly convinced by those arguments, but those are the sorts of things that would be raised. And in a context of criminal law, you have to prove intent beyond reasonable doubt. So again, in the case of Gaza, where there are multiple reasons for Israel to go into Gaza, then I think it could be challenging. But it would depend on collecting the evidence, and you need to see what that evidence was.
High-level rhetoric. What you actually need to find is evidence of elite planning across the government, because you're holding a government responsibility. You can find Netanyahu responsible, you can hold government responsibility. So you're really looking for evidence of elite planning across the government, which I did find in some cases in my mind.
Like that's be something. You those two extreme fascists in the government, Beverly here and National just blow. I mean, they said things with all the sword. I mean, they're no different to the Nazis. He said, can't that be attributed because they're in the government, or they will see through the cracks?
People have power to command.
Yeah. You'd have to look at the evidence, like the specific evidence. It's not, I think there's definitely material there that the prosecutor could use, but I can understand why they haven't charged that crime. So I think all I could say in response to just noting that it is difficult to prove intent, there are definitely strong indications that proof might be possible. But yeah, that's the fact that we're talking about genocide demonstrates that we're sort of in that territory. It's just about what evidence could be collected.
Thank you.
Yeah.
Yeah. Does any of the social media stuff that the Israelis IDF soldiers post showing them committing atrocities, does that count as evidence in genocide, and how can that be proved? Because honest to God, some of the stuff I've seen has given me nightmares. And yet, there doesn't seem to be any pushback against those soldiers. Are they liable to be prosecuted by the ICC, crimes against humanity? Because they have actually posted stuff, so they've incriminated themselves, and there's been absolutely no consequence in terms of the Israeli government pushing back and soldiers and their behaviour.
Yeah, so definitely evidence that soldiers collect themselves could be incriminating and could be used before the ICC. I think one thing to note about the ICC's jurisdiction is that it really is meant to be a court of last resort, so that you're not going to see lower level Israeli soldiers before the ICC. What instead you'd be looking for is leadership, and that's true across other situations. Although, in other contexts in the ICC, the only people they've managed to arrest have been the lower level people in some African context. So it's as a matter of law, yes, they might be liable for those crimes. And again, it would depend on the evidence. So I can't sort of answer the question in the abstract. Yeah. Yeah. I mean, it's not inconceivable. Not inconceivable that you see universal jurisdiction in domestic states applying to individuals who have done those things, and that's definitely conceivable that you might see national courts. Again, I think it would be I think politically that's perhaps more difficult to imagine than saying yes, as a matter of law, it could happen. Yeah.
Be there.
Yeah.
It says bringing about physical destruction in whole or in part. In
Yeah.
part seems to be very opaque to me.
Yeah.
Being in national law.
So not an expert on the Genocide Convention, but I'd say that's there so that you don't have to show that the state was trying to destroy every single person. It was enough for them to destroy part of them.
Basically, for example, genocide in Srebrenica, Rwanda. So, but Srebrenica is maybe easier because it was not full population of Muslims in Bosnia and Herzegovina, but these 8,000 of men and boys in this particular area. So this was not all Bosniaks or ethnic group, but these 10,000 men and boys that were killed on that particular day. And just that, so how difficult is to prove genocide? I have a colleague and friend who is a state prosecutor in Bosnia and Herzegovina, and we often discuss some cases, and he has been just prosecuting war crimes, crimes against humanity, and he can prosecute genocide as well. But he said no one dares, even when they have situation in Bosnia. So we have in Srebrenica that was prosecuted as genocide, but there were other massacres in Bosnia that could potentially be charged as genocide, but they said that prosecutors are just that they don't dare because of intent. It's so difficult. That's why we have just few cases where actually it's proven that there is a genocide, but it's very, very complicated. So you really need to go for war crimes and crimes against humanity, which are like much but easier to prove. So they choose to go there rather than.
I'll go.
Be consistently produced about on every case is their rationale is right to defend. So if it's right to defend, that could be an excuse for everyone.
Yeah.
So in fact, it cancels that.
Well, I mean, there are some things that you couldn't, like forcibly transferring children, that wouldn't. As in you couldn't use that self-defense as a rationale for that, or these last two would be unavailable. But definitely the first three could come about as a matter of armed conflict. So yeah, absolutely.
There are exceptions to self-defense. It's
Yeah.
not like unlimited, but it's all this self-defense. So there is this proportionality.
Yeah.
So it has to be proportional. So they can't just claim this is self-defense because everything that, again, its rules and exceptions in self-defense. So no, it's not that easy at all. I mean,
I'd say on the matter of proportionality too, it is subjective or not subjective, but it's a value judgment. It's a question of judgment, and I would say that amongst international lawyers, Israel's conduct in Palestine is now in the disproportionate mode. Like I don't, and necessity. And so I think we're in and I don't think that would be a controversial statement. If I went to a US military law conference and I said, I think Israel's behaving disproportionately in Gaza, I think the military people sit in the room and go, yeah, no, that probably makes sense. Yeah. Yep.
I guess the argument that's always used is self-defense against Hamas. But as the occupying power, what is the right of Hamas to exist in that sort of
Good question.
do you get what I'm going there?
So in Gaza, it was unclear whether it's occupied. There's a range of views about that, and that's because Israel controlled the borders but didn't control didn't have boots on the ground in Gaza prior to the invasion late last year. The legality of Hamas within the state of Palestine, that would, I guess, really be a matter of Palestinian law. But I don't think is there a part of international law that declares some non-state armed groups unlawful? Would it be? I mean, they are.
I mean, they're elected, right? They were the elected power, so there'd be a lot of tests in international law that say they were.
They're not.
They're like, all the closest is Ireland, you know, where you have to pay the IRA. But yeah, it's a tricky business.
I mean, they're not recognised by other states as the sort of the state of Palestine. In terms of, I think, your question about occupation law and what it allows the occupier to do, they have an obligation to maintain security and maintain the safety of people within the territory. And so part of that would be a kind of policing function. But occupation as an idea in the Fourth Geneva Convention was established as a temporary state that would come to an end. And so what you saw in the ICJ decision of this decision in 2024, this year, that was so significant is they said at least in the West Bank, that the occupation had gone on for so long that it was clearly a sort of de facto annexation of territory, which is unlawful under international law. So it is harder to say whether or not a particular Israeli policy in the West Bank is unlawful. Not harder to say, you just need more information. I can't say it in the abstract. You need to look at the specific policy. But what the ICJ has said here is that an occupation that goes on for a long time and fails to respect the rights of self-determination and amounts to a de facto annexation of territory becomes unlawful in international law. In terms of Hamas's rights, there have been some people sort of argue various arguments about self-determination or rights of wars of national liberation. I don't know enough about how those tests operate in international law to have a view, but it's complicated.
Yeah, I mean, if you want to befuddle a student, you say, what's the difference between a terrorist and a freedom fighter under international law? And they come back 7 years later.
Yes. But how do the exams?
Yeah, we don't teach them. Usually the answer is time, right? Time. Yes. You win or not, you know, if you're Sinn Féin, IRA, ANC, they won. Now they're credible international actors. It's a really tricky. But they still held to the same laws. So
Yeah, there's
held to the same laws.
As Israel.
As Israel, but they're non-state actors, so they're, or we think.
Yeah, they don't have the same rights, but they have the same obligations.
So they're also not allowed to give shields. They're not allowed to. They weren't allowed to attack take all these hostages. They weren't allowed to commit. So they're all still war crimes, but they don't cancel each other out. So just because Hamas committed lots of crimes doesn't mean Israel's allowed to commit lots of crimes, right? But they're both held responsible. So Hamas isn't let off because of the illegality of the occupation. So it's a really complicated business. So most international lawyers would say everyone's going to jail. All going to jail. They cross the border, they're going to jail.
Up the back.
Have the right self-defense against states. So I don't think I'll ask the state.
That's yeah.
Human using people as human shields, you know, like you mentioned the hospital and you mentioned schools, but you know, you've got a longer base here in the middle of Brisbane. Is that everybody using us as human shield?
So under international law, states are obliged to separate their civilian and military populations from each other. But you see in Enoggera, I don't think they built that there for the purpose of having human shields. I think it was for convenience for the people living at that base.
Particularly guerrilla arms.
Yeah.
They're forced out in the middle of
Yeah. That is their international law obligation to keep civilian and military separate. I mean, again, all that would tell you is that Hamas was in breach of some of its international obligations. Whether or not Israel's in breach would be a question about what they were targeting in terms of the impact that it could have if Hamas puts its military base inside a hospital, as per the allegations of Israel, which I'm not saying are true or untrue. That would change the status of the hospital into a target. So that's why it's important for non-state armed groups to respect that, because that's what protects the civilians in their where they're living from attack if they keep their bases separate. But of course, these rules were written in by states in a different context, and the states aren't that interested in making things easy for non-state armed groups. I mean, you could tell a whole story of international law where it's about states trying to maintain control of military force and making sure any challenges to that can't get at them. So the non-state armed groups have all the obligations, none of the rights.
They have to defend something. One thing talk about the hospital early on, and that just displayed involving residential stuff. That's what could be quite follow.
Yeah, I mean, I think that there's a strong argument that's fairly obviously disproportionate to any military advantage that might be gained. And same with the sort of starvation, using starvation as a method of warfare. Any kind of military advantage you might gain or military necessity from carrying out these aid checks would be outweighed by the impact. So it's a value judgment based on proportionality. There's a couple more questions.
It is in line with the conflict agreement and that may actually prove intents that beyond the correct investigation, but it's a early question. So.
Yeah.
Yeah. Well, this is terrible. We have to choose. Oh, I'm sorry. We've come to 3 o'clock and we're going to get kicked out of the room. But we can have a bit of a chat afterwards. But I wanted to. It is 3 o'clock, isn't it?
Yeah.
Oh, right. But that doesn't mean we can't keep the conversation going out in the foyer. But I just want to say thank you so much to Simon for it. Really amazing. Well, that's a lot to get through. Global law now. And I wanted to also say a couple of things just very quickly about, please join the UNAA if you haven't joined. If you've joined today, we'd love to have you as a member. And please come to our lecture, which is really important, which is on a very similar subject. We've got Nasser Mashini, who's the president of the Israel-Palestine Advocacy Network. He's sharing a stage with Louise Adler, who's the advisory committee member of the Jewish Council of Australia, and they'll be speaking on the UN Day of Peace in the beautiful St John's Cathedral, 21st of September at 6:30, and it's an opportunity to really think about how we move forward with some of these difficult issues. But now you've got so much international law in your pocket, you can wield in arguments, and maybe help you understand the headlines about why things are happening the way they're happening. So grateful for your time and attention.